開會時間到啦，咁
Members, this is the appointed time, and we have a quorum. So I call this meeting to order. At the meeting of the 14th of February, members raised some questions. And since then, this paper, CB bracket 1299/2025 bracket 1, was prepared. And then the administration has given a response, and that's CB bracket 1299/2025 bracket 02. I will invite the administration to come in first, and then I will invite them to walk us through their response. Members, if you would like to put questions to the administration, please press the request to speak button. So let me welcome the administration to our meeting. Permanent Secretary, would you like to walk us through your response to matters raised by members at the last meeting? Just very briefly. Thank you. Chairman, yes, we will briefly go through our response to the issues raised at the last meeting. There are 4 issues, and I will go through each of them. For the first point, members at the last meeting made a suggestion of amending the long title as well as Section 3.1 of the Protection of the Harbour Ordinance. And that is protect and preserve the harbour as a special public asset and natural heritage of Hong Kong people. And that's the original version. We would like to take on board the member's suggestion and amend the term Hong Kong people to Hong Kong. In Chinese, 天然財產 will be amended to 自然遺產, meaning natural heritage, instead of natural property in the Chinese. We believe that this amendment will make the Chinese rendition consistent with the English text. The second point relates to another question raised by members, and that is when it comes to undersea tunnel construction. Can we give some examples? Now, I'd like to invite members to take a look at this diagram. We have made use of this project that is a Central Kowloon Route project. So as you can see on the slide, on the top right corner, you will find 2 photos showing the temporary reclamation works relating to the Central Kowloon Route. Now, the purpose of the temporary reclamation is twofold. First, a temporary working platform can be set up, and second, a temporary coffer dam can be erected. The function of the coffer dam is this. Say if we are to bore, say, piles or form a structure under the sea, under the water surface, we can then proceed and construct the alignment of the tunnel for this section, and then we build a coffer dam such that water can be drained in a sense and that the seabed will be exposed. The tunnel structure can then be laid at the bottom of the sea, and that is on the seabed. Afterwards, we will cover the cut portion, and then the working platform can be removed. So that's one example of temporary reclamation. For Central Kowloon Route project, we just illustrated that this part relates to a temporary reclamation instead of a proper or permanent reclamation. Now, the tunnel structure is lying under the water surface. It doesn't involve the formation of land, so it's not permanent reclamation in the Central Kowloon Route project for this section. But there are other construction projects relating to infrastructure across harbour tunnels. There may be parts of the tunnel that protrudes above the water surface, and then some form of structure will have to be built, and that may be regarded as permanent reclamation. Now, for this example, the Central Kowloon Route project, it involves only temporary reclamation. It does not touch upon reclamation projects as defined under Cap 531, that is protection of the harbour ordinance. So that is our response to the question raised by the member at the last meeting. Now I come to the third point. It's a point of clarification. It's about placing of, say, a device on the seabed for stabilizing some other devices floating on the sea surface, such as pontoons. Then will the device be regarded as reclamation? As you can see in our response, if the works do not involve piling works on the seabed or foreshore, if the device can be taken away anytime, then it's not covered by this ordinance. Again, you will find 3 pictures and 2 examples here. The first 2 photos show you devices that are not regarded as reclamation works in Cap 531. In fact, they are floating pontoons or temporary platforms. Now, we have fixed devices on the seabed, such as anchors for stabilizing the floating platforms. The platforms are erected for some one-off events, and they can be dismantled right afterwards. I'm sorry to interject, Permanent Secretary. Can we switch to the next slide, please? Please continue. I'm sorry, we haven't prepared the slide for what I'm talking about, but you will find these pictures in our written response. If you don't have that with you at the moment, you can go back and check. Just to say that these are 3 photos showing devices that are not reclamation works. Now, for the first 2, we need to bore some piles onto the seabed to build a platform for embarkation and disembarkation of cruise passengers, or yacht passengers rather. Right, members, you can refer to the written response. It has been forwarded to members. Both the Chinese and English versions are ready, in fact. Now, to take the last question raised at the previous meeting, when it comes to the overriding public need assessment report, members asked, apart from providing this report in hard copy, whether it should be published by electronic means as well. Now, there are some publication requirements, and we do agree that apart from making available hard copies of the report, we should allow publication by electronic means. So we're going to move an amendment. As for the content of the report to be published, we don't propose making express provisions in the bill, but later on we will publish guidelines for the specified officers to publish such reports in a manner that is accessible by the public. Right, 2 members who would like to ask follow-up questions. I will invite Dr. Loy Kwok to kick off first. 4 minutes. Thank you, Chairman. I really appreciate the administration's response to the issues raised at the last meeting. Take the first point, for example. Protect and preserve the harbour as a special public asset and natural heritage of Hong Kong people. The administration has taken on board our suggestion and amended the wording to read Hong Kong instead of Hong Kong people. In Chinese, likewise, the administration has agreed to adopt 自然遺產 instead of 天然財產, in English meaning natural property, because when you use the term property, there may be valuation involved in the future. So we should stick to the literal meaning in English for the Chinese text to read 自然遺產. And I also appreciate the response relating to whether the floating device on the sea surface constituted land formation in the ordinance. I think the administration has provided a very clear reply that such devices are not to be regarded as land formation. For example, for pontoons that floats on the sea surface, anchored by some fixed devices, they would not be regarded as reclamation. Now, I recall years ago I received a call for assistance. That is for water sports activity that was held in Shingmun River. A floating platform or some floating devices were needed for the purpose of serving the boats, and yet because of the presumption against reclamation, it took a long time to figure out how they could go about it. I really appreciate the administration's explanation. Responding to what Dr. Lo Wai Kok said, let me also refer to temporary floating pontoons. Like Dr. Lo Wai Kok said, as the matter currently stands, in general, when it comes to temporary floating devices, would there be any deadline as to when they should be removed? P.S. We don't have a hard and fast rule as to the duration of placement of the floating devices. Now, in our experience, for temporary platforms or floating pontoons, they're usually placed there for the purpose of some events, and they are usually taken away once the events have been completed. And that is why we don't think a hard and fast rule should be put in place to stipulate the duration. But what about the actual procedures? Is government approval required? Because there may be concerns that such devices may be placed there for a prolonged period of time, such that they are no longer temporary, but rather a fixture there. Since these devices do not involve reclamation, they are not covered by this ordinance. Now, usually when we talk about these events, such as events that happen in the Victoria Harbour, the Marine Department is in charge of marine traffic, and the department may be concerned as to whether these devices would affect other marine users. So the organizers must keep liaison with the Marine Department to ensure that the event would not affect the safety of any person at sea. All right, I think we can follow up on this. What is important is to provide a clear pathway and clear information for organizers of these events.
So,
Next, Mr. Andrew Lam. I would like to thank the administration for giving examples such as Central Kowloon Route and floating pontoons, but as I asked before, above the seabed, but below the water surface for structures located in between. They would need things to secure them. I am not exactly resting assured at having read the response. But I would say this, say 431A, I think we can refer to that because it would clearly define what a device is. And perhaps I will follow up on this matter then. All right, any response from the administration? I think we can wait until we get to that clause and then we can give a more detailed explanation. Thank you. Mr. Lee Chen-kung. When we talked about having to get more information on how the Marine Department will deal with applications relating to pontoons, especially when there is adverse weather, if the structure becomes dislocated and may affect marine traffic, is concerning. And what is going to happen? Is there any guarantee that must have them secured and whatnot? We should know more about that. I think the Permanent Secretary can follow this up with the Marine Department. All right? If members have no other follow-up questions, we'll move on to clause-by-clause examination. At the last meeting on 14th of February, we scrutinized up to clause 9, proposed new section 3E, E for Eagle. And we are going to start with the Chinese marked up copy. That is LC paper number CB brackets 11758/2024 brackets 02, page 12. That is the proposed new section 3F. We are going to start from this clause. And the legal advisor will look at the English text at the same time. I'll now ask the administration to start the clause-by-clause examination. I believe they will give a PowerPoint presentation. Whenever members would like to ask questions, please press the request to speak button. I will also ask the administration or members, when you speak, please refer to the page numbers of the marked up copy in Chinese. Yes, Ms. Leonie Lee. Thank you, Chair. We will start with section 3F, page 12 of the marked up copy in Chinese. On public comments on OPNA report, subsection 1. If a notice is published under section 3C3 in relation to an OPNA report, a person may, within 60 days after the first publication of the notice in the Gazette, give written comments on the report to the specified officer who makes the report. Subsection 2. If a notice is published under section 3C3 in relation to an amended OPNA report, the arrangement is actually similar. A person may, within 60 days after the first publication of the notice in the Gazette, give written comments on matters arising from the amendment made in the amended report. Subsection 3. Despite subsection 2, a person may not give written comments on matters arising from a minor amendment made to an OPNA report under section 3D. But there is an exception when the amendments are minor, say if they're just typos or just textual amendments. Subsection 4. Written comments may only be given under subsection 1 or 2 to a specified officer for a harbour reclamation by A. delivering it to a public officer who is authorized by the specified officer to receive it on the specified officer's behalf. B. Sending it by ordinary or registered post to an address specified by the specified officer. C. Sending it by electronic mail transmission to an electronic mail address specified by the specified officer. Or D. Sending it by fax transmission to a fax number specified by the specified officer. All right. We have two members who would like to speak. Dr. Tik Shi-yun, 4 minutes. Thank you, Chair. I have all along been concerned about whether the public can participate in the process, and I hope there is adequate public participation. I think there are 2 stages. So basically, there should be first a consultation paper, and then the public may make comments. And then after amendments are made, then the public may make comments again, right? So this is a 2-stage process, Ms. Leonie. I think we can put it that way because there must be first a report, and then for some reason some amendments are made, and then there will be an amended report, and then essentially there would be 2 stages. But then let me say this, the amendments can't be minor amendments. Right, I understand, Chair. So with the amendments, as you understand, would it incorporate public feedback? They would say in response to public feedback, we are making certain amendments. Would the administration provide some justifications for the amendments? In operation, would you include the justifications? Ms. Leonie Lee, I think the legal advisor asked about this as well, and the administration gave a response in our reply. We did not specify that we needed to give a written reply. We have referred to other pieces of legislation, such as Chapter 127, as well as Chapter 370. That is Foreshore and Seabed Reclamations Ordinance and Roads Works Use and Compensation Ordinance. So they may give some letters of objection after receiving objections or not receiving comments. There are different mechanisms to deal with such under the relevant ordinances. Say under Chapter 370, if we haven't received any adverse comments, or the comments are withdrawn after some negotiations, the submitting unit would be the Transport and Logistics Bureau. If there are adverse comments, then they will be referred to the Chief Executive and Council for consideration as well. This is different from Chapter 531 because when we receive comments, it doesn't matter whether they are supporting or adverse comments. We would just receive any kind of comments, so they may be supporting or adverse comments. Regardless, they will be submitted to the Chief Executive and Council for consideration. As for whether there will be a written reply, it is not necessary that we have to include this in the provisions. I don't think we have to spell it out in law, but then we're discussing it at the council today and our discussions are recorded. So let me say this, I have some comments. I want to know if the government has received feedback, what will you do with them? Will you have a way of openly responding to public views? You have given some examples, but I don't really know what exactly you're going to do still. So how can you address public views? Or how will the public know whether the government has or has not accepted their views? You said there would be a report, right? But is that report going to be seen by the public as well, the report that you're going to submit to the Chief Executive and Council? Chair, maybe let me supplement Ms. Leonie Lee's answers. So in 3F2, it says that there will be an amended OPNA report. So why is it amended? It is amended because, say, one after the original report was published, some members of the public gave some comments. Perhaps they queried whether the reclamation area had to be so big, and the government probably thought that was an appropriate concern, and they therefore made an amendment. And that results in an amended OPNA report. Essentially, that is amended in response to public feedback, and then the public would be able to give further comments on the amended report. As for whether we will openly say for the comments that we received during the 60-day period, how many comments are adverse, how many comments are supporting the project, and what is going to happen at the Chief Executive in Council stage. I think it is worth explaining what happened. I think we can have something like a legislative brief explaining the decision of the Chief Executive in Council, what factors the Chief Executive in Council considered, and the different comments received, for example, at least the types of comments received. Well, I welcome what they said about how they are going to deal with public feedback. Thank you. Mr. Andrew Lam. From what I heard the commissioner say on amendments, people may give written comments on matters arising from amendments. But from what I read, it seems to be different from what the commissioner said. It seems that comments be given not only on the amendments in the amended report. So I want to ask if my understanding is correct, Ms. Leonie Lee. Well, the intent is to distinguish between different scenarios. So for the second round, a notice is published with the parts that are not amended. Comments may not be raised. But then we are going to adopt a lax threshold. So we are not limited to exactly textual amendments. All right, next, Mr. Stephen Ho. Thank you. I want to ask about Section 3F, subsection 3. You said despite subsection 2, a person may not give written comments on matters arising from a minor amendment made to an OPNA report under Section 3D. So you define minor amendments to be, say, typos. And in B, you said it would be, say, the specified officer, say, the director of lands, etc. Can you spell out what is a major amendment? If you are reclaiming another 5 square meters, it may seem insignificant. But if you're reclaiming another 20 square meters, it may be a lot. So what will you say would be a minor amendment or something that has minimal impact? Can you be clear about what minor amendments mean? All right, we have talked about this when we talked about Section 3D. I'll ask Ms. Leonie Lee to provide more information.
Right, let me use area of reclamation as an example. For it to constitute a minor amendment, perhaps throughout the report, the area is stated as 50, and then in one of the entries is 500 instead of 50. So it's clearly a minor error or a typo. Now, Mr. Ho asked a question as to a really minor amendment. Well, say if it's typo, then it's entirely all right not to go through the whole thing again. But in 3D2B, in this officer's opinion, it does not materially affect the assessment set out in the report. Well, because from the perspective of a public putting forward any comments, we don't know whether it's minor or not. Well, I want to clarify that there is an and in between A and B in subsection 2. Now we need to rule out that it's not a it's a clerical or type error or typo, and that in the officer's opinion it does not materially affect the assessment. Right, understood, Mr. Bill Tang. Sorry, Chairman, I came in a bit late. Can I ask a question relating to the written reply of the administration dated the 14th of February? Well, we've already given sufficient time for the administration to respond to us, but I will give you the floor now. Right, as to whether fixed devices constituted land formation. Can you further elucidate this point? Because one hot button issue nowadays is to develop yacht economy, and even the budget has mentioned Hong Ham. So apart from say the breakwater or any other floating devices, can you tell us from your experience how this should be read? Right, I think the Secretary already responded to this point before. Who would like to take the question, please? PS. As I explained just now, now if a fixed device is installed on the seabed for the purpose of stabilizing the floating device on the water surface, then when will it be deemed land formation? It depends on whether the installation of the fixed device involves piling. Now let's say if it doesn't involve piling, and that the floating devices will be removed once the event has been completed, then usually it's not deemed reclamation. But if the device is installed by piling onto the seabed, then it may involve reclamation. Now, in fact, about berthing facilities for yachts, and in fact, we have a public landing steps in area 27 of Tuen Mun as an example. Usually, we have some sort of special piles called guide piles drilled onto the seabed, and then a floating berth can be placed above the guide piles for embarkation and disembarkation of yachts, and this can be regarded as reclamation. But what if no piling is involved, and that it just uses gravity? If it's a floating device on the seabed for long duration, well, we really need to look at the situation. Say in the future, if such device can be installed for the berthing of yachts without piling involved, then I think that we will take a closer look at this rather complex situation. So that means the construction method would affect the determination. Ms. Lee, please continue. All right, I move on to 3G. about submission of the report to the Senior Council and what the report entails. Subsection 1, the report should specify the assessment, and if the report is amended, the latest version of the amended report should be submitted. And then either of the following should be submitted as well. Say if the report is not amended, then all the written comments on the report should be submitted as well. Or if the report has been amended, then according to this capital A and capital B here, both should be submitted. Capital A reads all the written comments on the report should be submitted, and then capital B, the written comments on matters arising from the amendments. And then it reads here, every version of the amended report should be submitted to the Chief Executive in Council as well. This deals with the submission process, and midway of submission to the Senior Council, the report is amended, and some comments on the original report have been given as well. And in all fairness, all the comments and the report, including the amended report, should be submitted to the Senior Council. Next, submission period. In short, the report should be submitted 60 days after or 5 months after 60 days after the first publication. Likewise, for the amended report, after the report has been published for 60 days in the Gazette, it is to be submitted to the Senior Council within 5 months. Subsection 3. In the event of an extension, the Financial Secretary will receive an application. If the Financial Secretary considers it appropriate, then the submission period may be extended for 2 months. So only to the satisfaction of the FS, and if another extension is needed and another application may be made to the FS, it can be extended for on not more than 2 occasions and for 2 months for each extension. But a further extension will be granted only in exceptional circumstances. In other words, at the lapse of 5 months, then under 3A, another 2 months may be granted, and then under 3B, another 2 months may be granted. Mr. Andrew Lam. 3G2. I'd like to have an explanation on 5 months. It doesn't spell out exactly which date. In fact, it says here within the submission period. So, in other words, is it that the report should be submitted within 5 months? Is it possible to add the Chinese word to mean within here? Now let me explain this part. Well, I think we're referring to the deadline, in English meaning submission period. So if the deadline falls on the 30th, then that's the deadline of submission. In other words, you are required to submit the report before the deadline, on or before the deadline, but not after the deadline. But according to the DOJ, well, I see the DOJ representative keep shaking his head. Let's hear from him. I'm sorry, I got rather emotional just now. For 3G1, it says here that the report should be submitted within the period determined according to subsections 2 and 3. So it's about a period of, say, weeks or months. And then if we read subsections 2 to 3, you will find 5 months, and then extension of 2 months, etc. If we also add the word within here, then it means the officer must, within the period determined according to subsections 2 and 3, and then it's within 5 months and within 2 months within the submission period. So there is no need to add the Chinese word to mean within again in subsections 2 and 3 because it's spelled out in subsection 1. All right, all clear? Please go on. 0014, determination of Chief Executive in Council. So that's 3H. It sets out how the determination is to be made and the public notice. Subsection 1, on receipt of the report according to 3G, as well as the written comments, the CE Council may determine whether the presumption against reclamation is rebutted for the harbour reclamation. And then subsection 2, once the determination has been made, a public notice should be published as soon as practicable. Subsection 3, the notice must state the determination made. Subsections 4 and 5, in the event of more than one determination, how should things be decided and what are the correlations? Subsection 4, once the CE Council has made a determination, in the event of an amended report being received, the CE Council will make another determination on the basis of the latest version of the amended report, and that's called a new determination. Now, the effect of the new determination in relation to the original determination can be found in 5A. 5A reads, the new determination takes effect on date on which the notice under subsection 2 is first published in the Gazette, and it will substitute the original determination on that date. The new determination does not affect anything done in respect of the harbour reclamation according to the original determination before that date. So that explains the relationship between the new and the original determination. So to answer the legal advisor's question on original and new determination, I'd like to say the following. That is, whether there is any need to differentiate between the original and new determination made by the CE Council. Our answer is in the negative because both determinations are made under 3H. The legal advisor also asked the following. Now, if the new determination is such that the presumption is not rebutted, contrary to the original determination, then will restoration works be required for land already reclaimed under the original determination? Our explanation is that from the CE Council's approval to actual commencement of works, statutory procedures will have to be gone through. So that means after receiving an original determination from the CE Council, the Works Department will need to, say, conduct public consultation as well as obtaining the determination from the CE Council, or approval rather, before actual works can commence. So it takes some time from getting a determination to the actual commencement of works. Now, in the interim, it is possible that a new determination may be made, say, after receiving further written comments pursuant to 371. There may be a change of mind in relation to, say, because of the method involved. So there may be a new determination, but at that point, the government is still going through statutory procedures. It hasn't reached the stage of actual commencement. Now, when we come to the stage of actual reclamation works going on, then by that time, the statutory procedures will have been completed. And it is quite unlikely that a new determination will be made, especially a new determination that rules that the presumption is not rebutted. So it is highly unlikely. Well, despite being highly unlikely, what happens if it does occur? You still need to explain what happens. It depends on the new determination. Of course, here, can you tell us whether works already completed will be accepted or not?
I probably didn't make it clear. Say with 5C, it says the new determination does not affect anything done in respect of the harbour reclamation pursuant to the original determination before that date. Dr. Teck Chi-yun. I actually have reservations about this section. Probably much more than other sections in the bill. We have this ordinance to regulate the government's work, and there has to be proper consultation, and we need to make sure we are not acting against public interest. We do want to relax restrictions so that the government can take forward projects that can benefit the public. But then here, it is that the new determination, the determination is to be made by the Chief Executive in Council. So reclamation is initiated by the government, and all along it would be just the government making all the decisions. We need to have someone overseeing the government. Instead, the government is just making its own decisions throughout the process. Does it go against the intent of legislating this process? And I also want to ask if your bill will affect the checks and balances in place. So the determination is to be made by the Chief Executive in Council. Essentially, it is not completely disclosed, the deliberations. So will the public have enough information to lodge a judicial review? So first of all, the determination or the whole process is just within the government, and the public may not have adequate information to lodge a judicial review after the process. So does it mean that there is no public participation in a way? Well, I think we did talk about this earlier. I'll probably let the Permanent Secretary answer the members' questions again. The member is worried about checks and balances with the bill. I would say that the amended ordinance is an improvement from the existing ordinance, because we would spell out in the ordinance the mechanism. For example, like the commissioner said, there should be a report, the OPNA report, and then the OPNA report would be published, and within 60 days the public would give some comments. After that period ends, the comments would have to be submitted to the Chief Executive in Council for determination. We also said in the bill that the Chief Executive in Council should decide on whether the presumption against reclamation can be rebutted, they must consider a number of factors. So when the Chief Executive and Council makes a determination, it's not a free rein decision. They must have regard to the factors proposed to be considered in the bill before they can make a determination. In the end, if the determination made by the Chief Executive in Council does not demonstrate that the Chief Executive in Council has considered the relevant factors or relevant information, one may lodge a judicial review. So the member said after a decision is made by the Chief Executive and Council whether it can be subject to judicial review. It has always been the case that administrative decisions are subject to judicial review because it is an executive decision. So, say, if the determination made by the Chief Executive in Council, people are dissatisfied with that, people still have the right to lodge a judicial review. Dr. Tick. Excuse me, I just pressed the button wrong. Can you please cancel my other round? Let me say this. The Chief Executive in Council would consider some factors in principle, but how can the public know that they have thoroughly considered the relevant factors? If the public doesn't even know, how can they justify the lodging of the judicial review with the court? I think, Dr. Tick, what you said with executive decisions, if people think that these decisions are not lawful, the existing practice has always been that people can lodge a judicial review. That has always been the case. I will probably let the Permanent Secretary respond to your questions regardless. Permanent Secretary. Indeed, sometimes records are not made available to the public, but as long as the public think that they are justified, they can lodge a judicial review in relation to an administrative decision. After a determination is made by the Chief Executive in Council, if it has a serious impact and it is highly relevant to public interest, we would issue something like a legislative brief to tell the public about the considerations of the Chief Executive in Council. I believe this is a document that can be made publicly available because it will be made available to council members. Mr. Andrew Lam. No matter how much I support the bill, I think we need to understand some have reservations. Some think that the government may abuse the process. Against this backdrop, I think we should refer to H, Section H. I understand how or why you drafted Section 3H this way. Say if the Chief Executive does not have notice of the non-compliance at the time a determination is made, the validity of the determination is not affected by the non-compliance. So the public may be worried. So can you assure the public that you would minimize the possibility of this happening? I believe the Chief Executive in Council would read all of the documents submitted and they would have trust in the specified officers. I don't want to read this part wrongly, so can you please clarify this if I am wrong? Thank you. Permanent Secretary, thank you, member, for your question. You were referring to, I believe, specifically subsection 6 of section 3H. That is, if the Chief Executive in Council has made a determination and the Chief Executive in Council does not have notice of the non-compliance at the time a determination of the recommendation is made, the validity of the determination is not affected by the non-compliance. Let me first say this. The possibility of this happening is unlikely. So first, there would have to be in compliance, and that is not likely going to happen in the first place. You may ask why. But let me say this. With drafting, we have already considered the relevant possibilities. And this is not found only, the similar wording is not found only in this bill. It is also found in the town planning ordinance. That is, if the Chief Executive in Council does not have notice of the non-compliance at the time of making a decision, the validity of the decision is not affected by the non-compliance. This is to provide some sort of certainty, because if an issue is identified afterwards, or a non-compliance is identified afterwards, it should be the case that the decision should continue, provided that the non-compliance does not significantly affect the determination. Okay, so this is not exclusive to this bill. It is, similar wording is also found in other legislation. I think you should provide a clear explanation like this when others are doubting this. Permanent Secretary, what is your exact answer? I would say this. We already have similar arrangements in the town planning ordinance. Thank you. Dr. Lo Wai Kwok. Thank you. At the last meeting, the public hearing, some members of the public thought that their public's right of lodging a judicial review has been removed by this bill. I believe Ms. Bernadette Lin explained very clearly on that day that was not the case. And on that day, I said what I thought about the issue, and I would say this: the proposals did not come out of thin air. There would be detailed planning, and in the end, the determination is made by the Chief Executive in Council. And as Ms. Bernadette Lin said, and it is my understanding too, that during the process, the Chief Executive in Council would make a determination and the process would be clearly recorded. It's not something that will be sudden. It is not that they are trying to remove the right of the public to lodge a judicial review. That is not the case. I think we have to make clear of that. I think members understand this as well, but let me just take this opportunity to make clear for those watching the meeting that they should not be confused.
Now, going back to the clauses, my feeling is this. When it comes to not only reclamation but other matters, I think that the determination process is reasonable. This is what the logic should be. Anything to add from the PS? I agree with Dr. Lo Wai Kwok's point. The amendment bill seeks to set up a mechanism, so it's an improvement from the initiating department's report will have to be prepared, views will have to be collected for submission to the CN Council for their consideration. All these are expressly provided in the amendment bill. The bill also spells out the criteria for the CN Council's consideration. Like Dr. Lo Wai Kwok said, whilst putting in place these improvement measures, we do not take away a citizen's right to file a judicial review against the determination if he's aggrieved. Dr. Tik Chi-yun. Well, many members were also present at the public hearing, and I think one thing clear is that we all heard the questions raised as well as the objections from the floor. So just to clear this up, I want to make sure that there are checks and balances and that this harbour is for public enjoyment. So we want to do good. As I understand, this determination will be made by the top echelon of the government. Now, have you considered delegating this authority of making determination to, say, the Harbourfront Commission, with which is more representative of the public? Have you thought about that? Well, the Harbourfront Commission has a role to play in the process. After we've completed the OPNA report, as we will seek views from the public for 60 days. So we will consult the Harbourfront Commission as well as one of the stakeholders, so they do have a role to play. About delegating this task to the Harbourfront Commission, as per members' suggestion, well, let's consider the development process. Now, after we've prepared a plan and after we've gone through the Town Planning Board, we will submit the plan to the CN Council for approval. For roadworks, likewise, after we've published the project in the Gazette and collected views from the public, the Works Department will then submit the proposal along with the railway alignment or the road alignment to the CN Council for approval. So the highest decision-making body in the executive is the CN Council. That's how it works. Of course, I understand ultimately it's for the chief executive in council to make the decisions as top of the executive. Now, you mentioned public participation and the Town Planning Board. After preparing the report, maybe there should be another round of discussion by the Town Planning Board or by the Harbourfront Commission before submitting the report to the CN Council. Would it be too cumbersome to? But there is a process for the public to be involved, to be engaged, right? Yes, we consult the Harbourfront Commission, and that's one of the ways of public participation and collection of views from the public within the 60-day period. Now, the role of the Harbourfront Commission is to make recommendations, but ultimately it's the CN Council that's which is the decision maker. Now, please continue. Before moving on to part 4, I'd like to take the legal advisor's question. The legal advisor asked about the justifications of the CN Council's determination and the appeal and review mechanism. As I explained just now, we're going to provide a written reply setting out our grounds. Now, according to the proposed mechanism, appeal and or review is not allowed. Now, we consider that this determination on whether the presumption is rebutted happens at a rather early stage. Following the determination, we'll still need to consider, say, revising and improving the proposal, and at that point we can further explore different arrangements. I'd say that the CN Council's determination is just the first step. We need to ascertain, for example, whether the next step can be proceeded with. So this is the first step, and as such, the appeal or review mechanism is not put in place. Now I go to part 4 now, 0016. Exemptions from presumption against harbour reclamation. 3 capital I. Interpretation clause. Chairman, if I may, I'd like to come back here later. We should first go to the exemption provisions. So I go to Division 2, Harbour Enhancement Reclamations, 3 capital J. Application for an HER or Harbour Enhancement Reclamation exemption. A specified officer may apply to the FS for an HER exemption. And then bracket 2, the application may only be made in the form specified by the Secretary for Development. Subsection 3, the information that is necessary for the FS to make a decision. That means these are factors for the FS to consider in making a decision, and these are necessary pieces of information. So if we compare 3J and 3L2, we'll be able to get a better picture. If we go to 3A, it says a plan delineating and describing the specified area of the structure, feature, or device set out in Schedule 2 to be constructed. So they should be structure, feature, or device set out in Schedule 2, and the plan should spell out the specified area of such structure, feature, or device set. Now let me turn to Schedule 2. We can learn more about the structure, feature, or device mentioned here. If we take a look at the slide here, you will find altogether 14 items. And then you can further break it down into 11 subcategories. The 14 items include promenade and boardwalk, cycle track, harbour pool, viewing deck, ramp, mooring, breakwater, seawall. Number 9, hangar, crane, and hard stand for ship repair. So devices and structure for ship repair. Number 10, wave absorption structure. As you can see on the left-hand side of this picture, we see this blackened, the black bits, and these. This part is the wave absorption structure. That means the energy of the wave or tides will be reduced because of the absorption structure. That can minimize the tidal waves. For this orange, for the part beyond the orange line, it doesn't come with the wave absorption structure. Number 11, facility for the operation of typhoon shelter and sheltered anchorage. In fact, these facilities may be the same as the items previously mentioned, so we just have a catch-all provision here. Next, water supplies, bunkering, or battery charging facility for supporting marine operations. Number 13, device for mitigating extreme climate risks. These devices may be involved in reclamation works. And in that case, we want to capture them so that they can benefit from the streamlined procedures. And then there are also item 14 and items specified in the schedule to the Foreshore and Seabed Reclamations Ordinance. So we have provided the items specified here, such as 14.1 Pier, 14.2 Landing Steps, 14.3 Harbour Steps, 14.4 Slipway, 14.5 Mooring Dolphin, 14.6 Beacon, and 14.7 Floating Pontoon. So to give members an overview, well, we can turn to C2679 in the English version of the Blue Bill for Schedule 2 or page 0036 of the marked up copy. Mr. Andrew Lam. I come back to the same example. That is, there is a structure above the seabed but below the water surface. So I'm talking about a device where no piling is needed. And if I now go to this provision 3L, it reads device, feature, or structure. But it is considered in terms of the area occupied. So in that sense, anything, any structure, device, or feature that is on the seabed and below the water surface would, in a sense, occupy some area, an area. So does it mean that it will be subject to this ordinance or not? I'm sure that it is not exempted because the structure I mentioned is not part of the 14 items here. I just want to clarify this point. Ms. Lee. Now, let me explain to Mr. Andrew Lam with the concept of the specified area. Now, if we go back to 3 capital I, where you will find the definition of a specified area. It means that in relation to a structure, feature, device, the total area of the harbour occupied underwater and covered at or above the water surface, so somewhat slightly above the water surface, whichever is the largest by the structure, feature, or device. So in other words, we will uphold this rule rigorously. We take the maximum area occupied in the calculation of the specified area because of this rule of not more than 0.8 hectares to be covered. So again, let me turn to one of our slides to elucidate this point. The first example is a structure that will span a larger area above the water surface than below, such as cycle track. There may be pillars or piles drilled under the water. They don't occupy a large area, but then you have a flat surface. Right, Ms. Lee, I don't think Mr. Lam is concerned about this particular example. I think he's referring to a structure that is erected on the seabed and underwater.
Do you understand what he meant? Maybe I can clarify what I said. Say, for the Central Kowloon route example, you said that the part that is protruding out of the water would be seen as reclamation, but for the other ones that are below the surface of water, it wouldn't count. But then, let me say this, for many underground utilities, they are above the seabed, but then they are fixtures. They are not exempted works either. So if you're taking a strict approach, they may be regarded as reclamation. So I wish to clarify this point. All right, Ms. Lee. Sorry, I misunderstood your question. For utilities, in general, they would be above the seabed and below the water surface. Under such circumstances, it is not counted as reclamation under the bill because it does not involve the creation of land. So under this ordinance, it is not regarded as reclamation. But these works would be covered by Chapter 127. And it may be subject to regulation under Chapter 127. I believe mainly it would involve Chapter 127, that they have to conform to the relevant requirements. I think there should be a clear basis, and we should know clearly what creation of land means. And they have all along been quoting the example of piling, but I don't think they ever mentioned piling in the ordinance being creating land. I think that we should have clear interpretations. If you are saying that we are going to follow Chapter 127, I hope this is recorded and this should be a clear basis. I thought I had a clear understanding, but once we start scrutinizing the provisions, I think some provisions are not clear enough that may confuse people, and there may potentially be disputes. Some, if they quote not Chapter 127, but this one, then you may have a problem, right? Chair, that's it from me. Thank you. I think it is good that we are identifying issues now and then we are clarifying now so as to facilitate public understanding. As we discussed earlier with the determination of the Chief Executive and Council, we have clarified the fact that it is actually similar in arrangement as other pieces of legislation. That is, it is existing practice. How things work with the lodging of judicial review and whatnot. Thank you. Dr. Lo Wai Kwok. On harbour enhancement works, they are set out in Schedule 2. So essentially there are 13 classes of works plus a catch-all provision in the 14th one. I believe all of these should cover all of the harbour enhancement works we know. My question is actually very simple. With technological advancements, if we have other types of works that could enhance the harbour in future, if we want to add more types of works to the schedule, is it going to be added or amended via negative vetting? Ms. Leonie Lee. Thank you, Chair. Indeed, as time passes and as technological advances exist, we will amend Schedule 2. And it is said before that we would amend Schedule 2 by a notice published in the Gazette by the Secretary for Development. And as said earlier, if amendments are made, it does not affect the determination of the Financial Secretary. Alright? Mr. Yu Pat Leung, I want to follow up on the question asked by Mr. Andrew Lam. I actually have a more illustrative example. I recently went to Sanya to visit a submarine project there. We would take a submarine for viewing. Of course, I don't think it is possible in the Victoria Harbour, but let's take this as an example. If we need to create a landscape under the sea, say if we want to put a stage there, I think that is exactly what Mr. Andrew Lam said. It is a structure above the seabed but below the surface of the water. Would that count as reclamation? I would say this again. I don't think it is suitable for what we are to be done in the Victoria Harbour due to the water quality, but I think with clearer seas, some may want to develop projects like these that would have people go underwater for tourism purposes. I therefore want to know clearly what the administration thinks about such projects. Permanent Secretary. We had different members ask different things, whether they are regarded as reclamation. I think we shouldn't refer only to the definition of the bill. We have to consider multiple factors. And let's think about specifically the interpretation. So reclamation is about creating land. And I think there are two important parts to it. First, there should be the creation of land. It is a key part. And another part is that where the land is created, it is formed from the seabed or foreshore. So when we think about whether it is reclamation, we need to think about where it starts, whether it is formed from the seabed or foreshore. And we have introduced the definition of seabed and foreshore in Chapter 127 in this bill. We have talked about below the line of the high water. And if it is below the line of the high water, it is likely to be subject to regulation under this ordinance. Let's take the member's example. If we are creating a set that starts from the seabed below the surface of the water, it is very likely to be subject to regulation under this ordinance. If the area is less than 0.8 hectare, they can go through the streamlined procedures. If the area exceeds 0.8 hectare, then they would have to go through the whole process, preparing a report and then submitting it to the Chief Executive and Council. So as long as it is below the surface of the water, if there is land created and it is from the seabed or foreshore, it would be seen as reclamation. It does not have to protrude out of the water. Right, so basically it is the case that even if it does not protrude out of the water, it would be reclamation. Sorry, I need to clarify something with the reminder of my colleague. We also need to refer to whether it is one of the 14 types of harbour enhancement works. As for the land where it is formed, whether it is formed above the surface, below the surface, and for the area in particular, we will refer to the largest area, regardless of whether it is above, at, or below the surface. I think the legal advisor has some questions about Schedule 2. Thank you. We have several questions. So for items 6, 10, and 13, that is for the mooring, wave absorption structure, and device for mitigating extreme climate risks. We wonder if the administration would provide more definitions because, say, for the merchant shipping ordinance and other legislation, they have defined the different types of projects. Ms. Leonie Lee. Well, we understand that there may have to be further explanations of what these works are. So we are inclined to promulgating a technical circular on this to explain the different types of works. I think at some point we did talk about for devices securing vessels, it would be seen as mooring. And I think the legal advisor also quoted the merchant shipping ordinance. I believe in that ordinance they had given some examples. But then with our types of works, there may be overlapping with the different types. And we want to take into consideration possible technological advancements. So we want to adopt the approach of giving more details in the technical circular. I think we can refer to CB brackets 17/2025 brackets 01. We talked about how mooring, wave absorption structure, and device for mitigating extreme climate risks, the examples, members may refer to it. Ms. Leonie Lee, please proceed. I think you had talked about sections 3I and 3J. Right, we were talking about how there were different types of harbor enhancement works in Schedule 2. And we were talking about how in Section 3J, a plan would be submitted to enable the financial secretary to make a decision. The plan would have to delineate and describe the specified area of the structure, feature, or device, as well as the specified area of the reclamation. Say for the pier, it may be the case that outside the pier area there would be reclamation done as well. Generally, it would be non-permanent reclamation. And this should be included in the area of the reclamation for the financial secretary's consideration. Now, let's go back to the definition of specified area in Section 3I, because we only talked about part of it. In relation to a structure, feature, or device means the total area of the harbor occupied underwater or covered at or above the water surface, whichever is the largest by the structure, feature, or device, it would be regarded as the specified area. If we look at a diagram, as you can see here, example 1, the slide, it is an elevated cycle track. So we would have the blue arrow part be counted as the specified area. If we have cantilevered structure above water, like we see here in the second example, that is an extension of a pier, say, it would be outside of the line of the high water mark, and there would be piles from the foreshore. So basically, it would be that a blue arrow here that is counted towards the specified area. For the hinterland part, we wouldn't count it in the calculation of specified area.
The third example is an underwater structure. In the schedule, we mentioned the breakwater. As you can see, breakwater has a wide base and a narrow top. So we consider the maximum area, and that means the structure below the water surface. Coming back to 3J, we mentioned the plan showing the specified area of the structure of the reclamation, and the information also includes the intended public benefits to be brought by the harbor enhancement works. Turning over the page, the relationship of the reclamation with any other reclamation in respect of which an exemption has previously been granted. In light of the public comments received, we have provided this part to avoid reclamation projects being splitted up so that in a piecemeal manner they can exploit the streamlined procedures or the exemption. So we expressly provide here that the information should include the relationship of the reclamation with any other reclamation that has received an exemption before. Final point, the impacts, including the anticipated impacts of those reclamations on the harbor. Now, I'd like to respond to the legal advisor's question in his letter in January. Paragraph 14, whether it's necessary to provide a list of information to support the application for HER exemption. Our explanation is that apart from applying for an exemption, the project proponent will still need to meet other legal and statutory requirements such as the EIA and other matters, and we believe that the nitty-gritty can be dealt with at a later stage. So here we provide that a preliminary assessment of impact should be provided. And then bracket 4, on receiving this application, the Financial Secretary may, by written notice, require the specified officer to provide additional information. Brackets 5 and 6 set out the follow-up action after a request has been made. Say a request for additional information is not acceded to, then the Financial Secretary may reject the HER exemption application. A notice should be published in the Gazette in a way specified in 5A to D, and that is 2 issues of the Gazette published in both Chinese and English on a website specified by the Financial Secretary, in 2 issues of a Chinese language paper and 2 issues of an English language paper. If the Financial Secretary rejects the application, the notice should also state clearly the ground on which the FS rejects the application, and that is the request for additional information has not been complied with. There is a question on whether the time frame can be extended. Now, unlike other requirements on the public view collection and submission to the CE Council, where they come with a submission period or a deadline, here the Financial Secretary requires the specified officer to provide additional information to help him consider the exemption. We don't think it's appropriate to set a deadline here. 3 capital K, withdrawal of application. Bracket 1. Once an application has been made, before the Financial Secretary makes a determination, the specified officer may withdraw the application. And on doing so, according to bracket 2 here, the powers set out in sections 3J brackets 4 and 5 and 3L bracket 1 are no longer exercisable in relation to this application. Right. For members' reference, we are on C2647 in the English version of the Blue Bill. 3 capital K. Next, Ms. Lee. 3 capital L. Harbour Enhancement Reclamation Exemption Decision. Right, do tell us the page number of the Chinese version. It's 0019, 3 capital L. HGR exemption decision. When we went through 3J, we already covered this part, and that means considerations of the FS in making a request. After receiving an application, the Financial Secretary may decide whether to grant or refuse to grant an exemption. And then, bracket 2, if the FS is satisfied that, and then it comes with a number of conditions, then the FS may grant the exemption. Now, these considerations are set out in A and B. Bracket A. The specified area in the application does not exceed 0.8 hectare. And by specified area, we mean the specified area of the structure, feature of the or device to be constructed. And then 2B, if it's in the public interest to carry out the reclamation. So what is meant by public interest? The FS will need to consider, for example, the intended public benefit to be brought by the harbour enhancement works, the reclamation of the relationship of the reclamation with any other reclamation in respect of which an exemption has previously been granted, and also the impacts, including the anticipated impacts of those reclamations on the harbour. After considering the above, the FS may grant an HGR exemption. Subsection 3, the FS must publish a notice in the manner set out in 3J5 as soon as practicable after a decision has been made. So for 3J5, it means publishing a notice in the Gazette on a website as specified in Chinese and English newspapers. All right. Bracket 4. The notice must state the Financial Secretary's decision, and if the exemption is not granted, the reasons for the decision. Brackets 5 and 6 set out condition that may be imposed. The FS may grant an HGR exemption subject to any condition that the FS considers appropriate. Bracket 6. After granting an exemption with conditions, the FS must specify the conditions in the notice. Now, I have a follow-up question. We find the works set out in Schedule 2 with an area exceeding 0.8 hectares. Now, I've heard views in relation to this point. if a number of these works set out in Schedule 2 are carried out at the same time, there will be a significant impact on the harbour. However, for 3LB3 here, that is Roman numeral 3, the impacts, including the anticipated impacts of those reclamations on the harbour. That means when FS makes a decision, the FS will take into account the number of projects going on at the same time in the harbour. Usually, reclamation projects span a long period, and if several projects go on at the same time, there will be significant impacts on the harbour. Well, the administration keeps records of reclamation projects, and we also checked whether projects will be carried out at the same time or within a very short period of time for FS consideration. Mr. Andrew Lam. In considering granting an HGL exemption, the FS may also impose conditions. Now, my question is this. Under what circumstances will the FS be able to detect non-compliance of the conditions? Is it according to the progress report to be submitted under 3Q? Progress report should be submitted annually under 3Q. Now, administratively, it's a long period of time. I don't think it's desirable. FS won't be able to detect non-compliance in time. So does it mean that FS may impose a special condition? Because according to 3Q, progress reports are to be submitted annually. Another report will be submitted on completion of the project, but that would be too late by the time the project is completed. My question is it sufficient for annual progress reports to be submitted for the FS to ensure compliance? Well, these provisions are all related. Ms. Lee, would you like to take this question, please? Yes, the FS may impose any condition when granting an HGL or NPL exemption. However, only harbour non-permanent reclamation requires progress report because it's a time-limited project, and the specified officer will have to submit a progress report. Now, the applicant is, after all, a specified officer, which is a government official, and he carries the statutory duty of overseeing the works. Despite not spelling it out in the bill, I'm sure that on a regular basis, this specified officer will check to make sure that the contractor in question will abide by the conditions imposed. Now, what we have in mind for conditions is, for example, when works will commence, or the provision of a round-the-clock passageway along the waterfront to maintain the continuity of the promenade. So, should there be a breach of the conditions, it can be easily detected. And the FS may suspend or revoke the exemption, as you can see in subsequent clauses, and that the exemption will resume its validity after the matter has been rectified.
就住呢樣嘢，
I think on this issue, I think I will ask further questions when we get to that particular clause. I think we need to consider the perspective of the public. While I do understand that we shouldn't spell out everything in law, I think the administration should provide adequate administrative guidance so that with the different scale of and nature of projects at a particular area, and the report should be submitted to the financial secretary. I think the relevant personnel should also make sure in terms of application at that very stage, they should already be able to identify that there is an issue, and they should make sure the financial secretary knows of the issue. I think you should provide clear guidelines to the relevant personnel for their handling. Noted. Thank you, Chair. We are now at Division 3, Harbour Non-Permanent Reclamations. For Harbour Non-Permanent Reclamations, it would mean, say, for the Central Kowloon route, we have working platforms constructed to excavate land in the sea and then put the undersea tunnel there. And as said in the definition, it would involve forming land from the seabed or foreshore, but then this would be removed subsequently from the seabed or foreshore. So we would call something like this a Harbour Non-Permanent Reclamation. Section 3M. MPR Exemption Application. Subsection 1. A specified officer may apply to the financial secretary for an MPR exemption. Subsection 2. The application must be made in the form specified by the Secretary for Development. Subsection 3. What information is required. And just like Harbour Enhancement works, that should be information that is necessary to enable the financial secretary to make a decision. That would include, say, in A plan delineating and describing the specified area of the reclamation. B, if the area exceeds 3 hectares, a description of how the area does not exceed 3 hectares at any time during the reclamation. Let me say this. For MPR, one of the conditions is that at any time the area should not exceed 3 hectares, which is why relevant information would have to be provided in the application. That if the area exceeds 3 hectares, a description of how the area does not exceed 3 hectares at any time during the reclamation. C, the expected date to start to carry out the reclamation. D, the expected duration of the reclamation. Beginning on the date mentioned in paragraph C and ending on the expected completion date of the works to reinstate the harbour affected by the reclamation. As you may remember, this duration should not exceed 7 years. E, the intended public benefit to be brought by the reclamation. And F, the adverse impact on the harbour caused by the reclamation and the proposed mitigation measures to minimize the impact. Subsections 4 to 6 are on arrangements to provide additional information. Subsection 4, the financial secretary may by written notice require the specified officer to provide within the period specified additional information that is necessary. And subsection 5. If a requirement made in relation to the provision of additional information is not complied with, the Financial Secretary may reject the application. Subsection 6. The rejection must be it must say in the notice that the application for an NPR exemption is rejected on the ground that a requirement made is not complied with. Next, Section 3N. Withdrawal of application for NPR exemption, subsection 1. The Financial Secretary may, before a decision is made, allow a specified officer. Let me say this. A specified officer may, before the Financial Secretary makes a decision, withdraw the application. Once a withdrawal is made, a written notice must be issued, and then the Financial Secretary would not be able to ask for additional information to be provided. So these are powers in sections 3N and 3O. Now, section 3O, NPR exemption decision. Subsection 1, the Financial Secretary may decide whether to grant the NPR exemption or refuse to grant it. Subsection 2, the Financial Secretary, if he is satisfied that the following conditions are met, may grant an NPR exemption. A. The specified area of the reclamation does not exceed 3 hectares at any time during the reclamation. B. The expected duration of the reclamation does not exceed 7 years. And C. Having regard to all relevant matters, it is in the public interest to carry out the reclamation. That would include 1. The intended public benefit to be brought by the reclamation, and 2. The adverse impact on the harbor caused by the reclamation. Subsection 3. Once a decision is made, the Financial Secretary must publish a notice as soon as practicable. And it is a notice that should be published, and it should say in subsection 4, A, the Financial Secretary's decision, and B, must. If the Financial Secretary grants an exemption, specify a period not exceeding 7 years beginning on the intended starting date of the harbor non-permanent reclamation concerned. Let me say this. If the Financial Secretary grants an NPR exemption, that stage would be something that is early on. The developer may not be able to say when works would actually commence. So the notice would say a period starting from the commencement of the works, and it should not exceed 7 years. Let's go back to 4B2. If the Financial Secretary refuses to grant an NPR exemption, the Financial Secretary should state the reasons for the decision. Subsections 5 and 6 are on the conditions that may be imposed by the Financial Secretary. The Financial Secretary may impose conditions that he considers appropriate. Subsection 6, if the Financial Secretary grants an NPR exemption, in the notice, the Financial Secretary must specify conditions that he is imposing. Mr. Andrew Lam, I just want to confirm something. With the calculation of the period of 7 years, let me skip to section 3 That would involve the suspension of such works So would it include, say, the period of suspension? Ms. Leonie Lee. I believe they would stop counting if the works are suspended. And then when works resume, then the 7-year period would start counting again. Okay, in that case, I will raise some questions relating to Section 3(b) because I thought the period of 7 years would count the suspension period. Well, we are supposed to end at 6:30, but then I think we should at least complete scrutiny of Section 3(p). So perhaps we can go into Section 3(p) and Mr. Andrew Lam may follow on the question. All right, we are now on Section 3(p), notification of intended starting date. Subsection 1. If the Financial Secretary grants an NPR exemption, this section applies. Subsection 2. The specified officer must no earlier than 6 months and no later than 1 month before the date on which the specified officer intends to start to carry out the reclamation, give a written notice to the Financial Secretary and publish a copy of the written notice in the manner set out in Section 3J5. That would include Gazetted in Chinese and English newspapers, Chinese and English Gazetted notices, as well as on the website. Subsection 3. A notice under Subsection 2A must specify the intended starting date. Since the works are about to start, they would already know the intended starting date, so they should be able to specify such information. Subsection 4. The Harbour NPR must not be carried out before the intended starting date. Mr. Andrew Lam, you have questions? Well, I am just referring to the wording in Section 3(b). I think perhaps the DOJ colleague can clarify the wording. Because from what I saw in Section 3(b), the period of 7 years should count the suspension period. I think, can you be clear? So in 3(2), if a suspension of an NPR exemption is lifted under Section 3U5, the permitted construction period of the exemption continues to run as if it had been extended by a period of time that is of the same length as the suspension period. So it says it continues to run. So I thought it would be counted within the period of 7 years. Yes, Ms. Zhang. Let me explain what 3(2) means and how it affects the permitted construction period. First of all, when an NPR exemption is granted, it would specify a period of not more than 7 years. So say for this example, it is 7 years, and suddenly there is suspension of the exemption, and then there was a lifting of the suspension. So the 7 years continue to run, but then during certain periods of time within that 7-year period, works are not done. So the permitted construction period would have the suspension period added. So say the period given is 7 years and there was a suspension period of 1 year. Once the suspension is lifted, with 3(2), it would have that 1 year added onto the permitted construction period so that there is adequate time for construction to be done. And 3(2) mentions a suspension period, and the definition is given in subsection 4 of section 3V. So it means the period during which the HER exemption or the MPR exemption is suspended. So if there is suspension within the permitted construction period, the permitted construction period would have been extended by the suspension period.
Salam. Now it's clear to me. But do consider improving 3V2, make it more accessible, because I've read it many times and I was still misled. Right, Mr. Zhang, how about this? Say the maximum period is 1 of 7 years, and then if it continues to run as if it had been extended, that means 8 years, for example. Since the FS has the power to extend the period by 1 or 2 years, you need to make sure that everybody understands this is rather complicated issue. That hinges on whether the FS grants an extension of the permitted construction period up to 8 years. So that's in fact the effect of 3V. For the permitted construction period, it doesn't cover the length of the suspension period under 3V2. So when FS considers whether to grant an extension to the permitted construction period, then under such in such a scenario, the length of the suspension period will not be taken into account. So this provision caters for the scenario. That sounds complicated to me because you're not supposed to take into account the suspension period, and then it is considered to continue to run, etc. So please note Mr. Lam's point, because a layman reading this provision could be easily misled. Chairman, usually I read the Chinese text, and if I'm not clear, I go to the English text, and then everything will be clear. But on this occasion, I find both renditions confusing. So please go back and consider improving that. I have no particular view on how the period is to be considered. Right, P.S. Mr. Zhang, please go back and see if you could improve this bit, make it simpler and easier to understand. Now, as I said just now, we'll pause after 3P. As for date of the next meeting, members will be informed in due course. Let me wrap up by saying that the administration will have to reply to a number of issues raised. So please give us the reply before we hold the next meeting. We've also made suggestions on improving certain provisions, and please also submit the proposed amendments to members for consideration. I hope that we can wrap up the clause-by-clause scrutiny next time and consider the proposed amendments as well. Now, about written submissions and views expressed by deputations and the public, I hope that the administration can give us a consolidated response as well before the next meeting. Members will be informed of the date of the next meeting, right? Anything more from the clerk? Members, if you want to move amendment to this bill, and if you want the Bills Committee to be able to discuss them, please tell us as quickly as possible. Hopefully at the next meeting. Do that as soon as possible. If circumstances permit, if we still have time, we can go through any proposed amendments from members as well. So members will be informed of the date and time of the next meeting. We'll resume the clause-by-clause scrutiny next time. Item 2, AOB. Anything from the floor? I don't have anything under AOB. If not, then the meeting's adjourned. Thank you.